Hello, good afternoon everybody, and welcome to the webinar on property guardians. Who are they and what are their rights? My name is Natalie Foster. I'm joined along with Iris Ferber. We're both housing law specialists at 42 Bedford Row. We've been practicing in housing law for many years now. And what we've found is recently there have been some issues in relation to property guardians. It's something that's come up, and so we thought it would be a good idea to have a webinar and really discuss the background to property guardians and some of the legal issues. So just to give you just an outline as to what will happen in relation to this webinar, both Iris and I will just set out the background to property guardians, set out in summary what some of those issues are, and we'll do that for the first 20 or 30 minutes or so of this webinar. And then thereafter, we'll open up the floor to you. There is at the bottom of the screen, there should be a Q&A function. Throughout the webinar, you're more than welcome to just put in any questions that you have that you want us to deal with or answer. To the right of that, there's something which says a chat. That's something that we're not going to be looking at. So if you've got the questions, put them in the Q&A and we'll hopefully be able to get to it and deal with those later on. We're hoping to have this all done and finished by 6 o'clock. Okay, so thank you very much. Let's get into discussing property guardians.
That's the cue for me to get the presentation ready, which I'm now going to seamlessly do like this. Oh. Okay, is it on the screen, Natalie?
Yes, I can see it. Wonderful.
Okay,
we got there.
Right.
All right, brilliant. So let's start off by looking at property guardians and what a definition is of a property guardian. So it's important to say at the outset that there is no statutory or official definition of a property guardian. So then what's important to do then is to look at what the relationship is between why we have property guardians. So essentially there are freeholders who are concerned about the consequences of leaving their properties, usually commercial buildings, empty or vacant for long periods of time. So those properties can be residential properties, but they're, as I said, most usually commercial buildings. And there's the risk if they're left empty that they are vandalised, or they could include them being unauthorised occupation in those buildings. And so therefore those freeholders engage the services and enter into contracts with companies. Those companies are property guardian companies and guardian providers. Those guardian providers then provide security services to the property owners for the protection of their temporarily vacant properties. So the companies, the guardian providers, arrange for the commercial property to be used for residential purposes by placing those occupiers, and those occupiers are the property guardians, into that property. And so therefore it's widely accepted that that guardian is someone who's entered into an agreement with the company to live in the building or even just a part of the building. And the primary purpose is essentially going to be for securing and safeguarding the property. So providing that measure of security for those vacant properties. So then when looking at those individuals who are in occupation of those properties, it then moves quite naturally to look at the next step, which is what is their tenure? And so, yeah, so when looking at what is their tenure, it just looks a bit odd there on the screen. So the starting point, it's essential that the operation of the guardianship scheme, that the relevant property can be returned to that freeholder, usually, well, must be with vacant possession, and usually with short notice, because the aim is those freeholders, we know, just want to prevent that unauthorised occupation or potentially vandalism. And so the occupiers the purpose really is to give them as little rights as possible, by doing as little as possible, because all you want them to do is just be there and achieve that primary aim. And so therefore that commercial nature of that arrangement depends upon that agreement being a license and not a tenancy. So this has been emphasised in the case of Camelot Gardens Management and Co, which you can see which is the first point on the slide. And in this instance, that agreement purported to be a license, and in this instance, it was found to be a license. Mr. Koo, in that case, unsuccessfully appealed that first instance decision where he was found to be a licensee, and the distinctions that were, and the cases that were discussed were essentially that the main case of Street and Mountford, which obviously looks at how you distinguish between a tenant and a licensee. It's obviously first important to recall that the particular language of the agreement, yes, is something that will be considered, but it's not going to be the be all and end all. So you can't just turn a tenancy into a license simply by calling it one. What you must do is look at the form of the agreement, but then also look in reality as to what's happening on a day-to-day basis, what's happening on the ground whilst those occupiers are in occupation of that property, and how are they being managed, and what rights do they currently have whilst they're in that property. And so obviously Street and Mountford held that if there's an arrangement, the following three characteristics would indicate the existence of a tenancy rather than a license. And those obviously are, number one, exclusive possession, number two, the arrangement for being for a fixed term, and number three, there being rent reserved. And so when looking at property guardianship schemes, it's more than likely that you're going to have those last two factors. It's more than likely going to be for a period of a fixed time, and there's more than likely going to be a license fee. So the key issue is going to be the exclusive possession. And that really is going to be the determining factor as to whether or not this is a license or a tenancy. And this was considered in the case of Camelot and Co, which was a license because there wasn't exclusive possession. And three things really to think about in relation to that case is that number one, in that instance, there was more than one occupier of the property. The occupier, Mr. Koo, had possession of his room, but then there were shared facilities, so shared bathroom and shared kitchen. And because there were multiple occupants of that property, one of the features of that particular agreement was that the occupants themselves decided what rooms they were going to have and how they were going to share out the rooms. But that was a key feature in this case in terms of it being something that wasn't going to allow him to have exclusive possession. The second thing was that there was a clause in the agreement which allowed the company to alter the property. If, for example, there were more property guardians that they wanted to put into the property, they would slice it up a bit more to give them more space. Again, this lends to Mr. Koo not having exclusive possession. And then thirdly, it was the degree of control that the property guardian had about that property. So there were features in that agreement which said he wasn't allowed to have people stay over the night, he wasn't allowed specific people in the property. For example, he had to stay in the property for 5 out of the 7 days of the week and seek permission otherwise if he wanted to leave. And someone had to be present in the property for at least 1 day, 1 hour in every 24 hours. So there were specific rules that they had to adhere to, which in this case led to it being they didn't have that exclusive possession of that property. But then it's obviously important to consider that these turn on the facts of the case, because there may be something else within the features and the natures of that particular agreement or the arrangement itself, which lend more towards it being a tenancy rather than a license. And so the looking at that agreement and how it in fact works will be key in deciding whether they're a tenant or a licensee. And then the third position, which I'll touch on briefly, is, are they a tenant or a licensee at all? And so there was in a case of Oxley and Living Guardians Limited. This case is a first tier tribunal decision where Oxley made an application for a rent repayment order. They made this application on the basis of that there was no HMO license obtained by Living Guardians Limited in relation to that specific property. And then after leaving that property, Oxley made an application for a rent repayment order because there was no license in place. And in this instance, those representing Living Guardians made the point, and they tried to make the point because it was essentially unsuccessful, that there was a personal contract and not a tenancy agreement or a license. And what they said was that essentially the agreement required that resident to stay at that property on a full-time basis for the benefit of the guardian company. And they did not have the exclusive possession of any room, whether it be a bedroom or anything at all. That, as I said, was an unsuccessful argument, but it could be an argument that one chooses to run in the future. And there's obviously scope for that to be done once you consider the particular facts and circumstances of each agreement. I will now hand over to Iris to move and discuss the next aspects, but Iris will be coming on to talk about the HMOs in any event.
Thank you very much, Natalie. Natalie, can you hear me okay?
Yes, I can hear you fine, Iris, thanks.
That's good. If you can hear me, then I'm hoping everybody else can as well. Okay, I'm going to talk to you a little bit about the rights that a property guardian may have against freeholder or against the guardian company. And the first question that comes up that people want to talk about and discuss is, can a property guardian be evicted? And I suppose what I mean by that is, can you simply turn up as a guardian company, change the locks and sling everybody out that afternoon? I think probably straw poll, most people on this webinar would say probably not. But if you can't do that, what can you do? And what does it depend on? Well, we come back again and again in the section of this webinar that I'm going to be presenting to the things that Natalie talked about in the first 15 minutes. And that is the status of tenant versus the status of licensee. Because if the guardian is a tenant, then as a matter of law, they are no different to any other tenant. They are entitled to all of the statutory protections that their tenancy would otherwise entitle them to if they didn't happen to be property guardians. And that comes back to the very first point that Natalie mentioned, which is that there is no legal definition of property guardian. Property guardian is simply somebody who lives in a building in order to secure it, who may either be a tenant or a licensee. So therefore, usual rules apply relating to security of tenure if the guardian is a tenant. And that leads on, of course, to the question, who is their landlord? We'll perhaps come to that a bit later, and there might be some questions about it. But if as a matter of law, and if on the interpretation of the contracts that are in place, the landlord is the freeholder, and say, for example, that the guardian company is simply acting as an agent of the freeholder rather than being the landlord. And if that freeholder is a local authority, and I saw from the list of participants that there are lots of people watching this webinar from London local authorities who I'm confident have guardianship contracts for buildings around their borough. So if you are the freeholder as a local authority and you have a contract that labels your guardian company as an agent rather than as a subtenant of yours, subleasing their own building, then you are the tenant, and this is assuming that the occupation of the guardians is a tenancy then those are secure tenants, and you have got a situation on your hands, and it's going to be difficult to get a vacant building. If the contract does amount to a sublease to the guardian company, and then it is properly speaking a tenancy in which the landlord of that occupier is the guardian company, then they will simply be assured short-hold tenants, and the protections that are available to assured short-hold tenants will be available to them. There'll have to be either a Section 8 or a Section 21 notice, which is valid, and all of the formalities will have to be complied with, and a court order will have to be obtained. But subject to those things, the guardian company should be able to get their possession back, so long as they comply with the normal rules for assured short-hold tenancies. If the guardian is a licensee, and remember, that doesn't depend on whether the freeholder or the guardian company is the correct landlord, that depends on the nature of the occupation. If the occupation is as a licensee, no exclusive possession, control by the guardian company of the day-to-day movements of the guardians, all of those things that Natalie talked about, then there is still some protection, but it's much more limited. It's simply the protection from Eviction Act 1977, which is the act that has those nice, neat, what we call Section 5 notices. It's a one-pager. You must give 28 days notice in writing to that licensee. And you must include a statutory warning or statutory form of words, which is set out in Section 5 of the Protection from Eviction Act, which is a set of words that gives that licensee information about the fact that the process of obtaining possession against them has to be done by going to court. So it tells them what their rights are as a residential licensee. And those are the protections that a licensee will have, whether or not the freeholder or the guardian is the landlord. So that leads on to the question of who evicts, who is the claimant to the possession claim. And that goes back to what I said before. It depends who is properly speaking, the landlord. If the guardian on the facts of the contract is merely an agent, then you as the freeholder, assuming that you on this webinar are organisations who are likely to own buildings rather than organisations who are likely to advise live-in guardians, but certainly those of you who are in local authorities and who are in firms of solicitors that tend to act for landlords, it's going to be the freeholder who has to bring the claim, who has to be the claimant, unless, as I said before, the contract, properly speaking, is a sublease and the guardian is in fact a leaseholder, a tenant of some kind themselves, because then they have the immediate interest in the land, and they are the ones who grant either the license or the tenancy to the occupiers. So those are the points about eviction. I can see there's been some questions in the Q&A, and we will come to those at the end of this initial session, because quite frankly, my IT skills are beyond flipping backwards and forwards between the slides and the questions. So we will look at the questions in a few minutes' time when we've finished discussing these slides. Disrepair claims. I know from my own casework that this is something that comes up a lot. Why does it come up? Well, of course, the reason why the guardian is in the building is very often because the building is in a poor state, and there is a risk that because it's empty and in a poor state, it'll get squatted. People will turn up who aren't supposed to be there, trespass and cause damage, exactly as Natalie described for the very first slide. And so these buildings tend to lend themselves to disrepair problems. And there is a big question about what do you do if the occupier who is unhappy with the condition of the property is making complaints. Really, I'm going to sound like a broken record, but it does depend on whether they are a tenant or a licensee. If the guardian, the occupier in the building, is a tenant, then the usual rules apply. They have Section 11 rights, they have Section 4 Defective Premises Act rights, they have Fitness for Human Habitation rights now too, under the amended 1985 Act. All of those things will be relevant. They will be entitled to bring a claim. they will be entitled to claim against the freeholder if the freeholder is their landlord. They'll be entitled to claim against the guardian company if the guardian company is their landlord, and they'll be entitled to seek specific performance, injunction, damages for the condition of the property. Absolutely different in relation to licensees. Licensees have very, very limited disrepair rights. In fact, you could say, strictly speaking, they have no disrepair rights properly described. And they certainly don't have any rights under Section 11 or the Defective Premises Act or Fitness for Human Habitation legislation, because all of those depend on the definition of tenancy in Section 13 of the Landlord and Tenant Act 1985, and a license is not within the definition of tenancy under Section 13 of the 1985 Act. So what they could have is contractual rights, but that's unlikely because guardian companies would be pretty silly to give guardians disrepair rights as a matter of contract when the whole point of the business model of providing guardians is to facilitate the security of buildings that are not in good repair, and creating disrepair rights for the people in those buildings would make a complicated situation a lot more complicated. So I would be very surprised in any particular case to find that there were contractual rights in the contract that the guardian has with the guardian company in relation to disrepair. Now, that doesn't leave the person who is occupying completely unprotected. Of course it doesn't. There are occupiers' liability rights. So going back to your law studies, if none of, I certainly haven't done any personal injury work, so this is definitely for me going back to my law studies. The Occupiers Liability Act 1957 is the one that deals with occupiers who are on a piece of land legally with consent rather than trespassers. So an occupier on land with the consent of the owner of that land has rights in negligence. There are duties of care not to cause injury to people who are lawfully on the land, and those rights will apply to guardians. They'll be entitled to those rights because they're general negligence rights in the law of tort. They are not landlord and tenant rights. They don't depend on any kind of landlord and tenant relationship. And of course, there will be environmental health implications of extremely poor, dangerous buildings. And it may well be that the guardian is able to ask the local authority to take environmental health steps in order to resolve any problems with the building. Of course, if the building is owned by the local authority, that's rather more complicated, and there are probably questions to be asked and answered about how on earth one deals with that, and one deals with a situation in which you are both the freeholder in charge of the building and you've also got occupiers of the building complaining about environmental health issues in the same building. But in principle, those rights are available to anyone who occupies a building and would be available to those guardians too. And the final thing we're going to have a think about is HMOs. A lot of the case law, all of the case law that Natalie talked about, although it deals with the issue of whether it's a tenancy or a license, the status of occupation, all of those cases have been brought, and the status as tenant or licensee is important because the guardian in that case is asking for a rent repayment order, or is seeking some kind of injunction or some kind of court order or tribunal order based on the allegation that a building that should have been licensed as an HMO has not been licensed as an HMO. And so although the issues relating to HMOs are in some ways different, separate from the questions of what rights does the occupier have in respect of their occupation, in the end it is connected. In the end, these things often come up together in cases that you'll come across. And so my answer to the question, is the building an HMO? My answer to that question is probably. The standard test for HMOs, which is going to apply in most cases of property guardianship buildings, the standard test is as follows. Is the building occupied by 5 or more people in 2 or more separate households? Well, for many guardianship situations, that will be the case. There will be 5 or more people in the building, and each of them will be living separately. It doesn't have to be all 5 sharing facilities, but at least 2, there is more than one family unit there that have to share either a bathroom or a toilet or a kitchen or any combination of those facilities. And then is at least one person paying for their occupation. So bear that in mind. If this is a guardianship model where the guardians don't pay anything, seems unlikely, but in theory that could happen. The guardian company could make all of its profit from its fees paid to it by the freeholder rather than by charging any fees to the occupier, but that's rare. Mostly they do charge license fees, and as long as one of the people occupying is paying a license fee, then that is sufficient for the standard test for an HMO. And then finally, is the living accommodation being used for any other purpose? And I know certainly from cases I have been involved in that sometimes guardian companies at least try to argue that they run an office out of the same building. There is some commercial use of the building that is an active commercial use, and therefore the living accommodation is being shared by non-residential use as an office, and therefore it's not an HMO. So that is something that is argued. Whether, as a matter of fact, the guardian company can establish it, it depends on the case. You will probably all be aware of cases in which guardians are very, very keen to avoid the decision that their building that they are operating is an HMO. They don't want to be in a situation where they're obliged to license because it's a cost for them, it's complex. And of course, if they haven't been doing it and they suddenly have to do it, then it leaves them open to a rent repayment order claim application to the tribunal by the one or more of the occupiers, which obviously they don't want either. So what else is there to say about HMOs? It's a complicated area. We could do a webinar about property guardians and HMOs and fill an hour just about the issues that come out of HMO licensing law and guardianship. But perhaps there'll be some questions about that in a moment. I can see already that there are 4 questions in the Q&A. So let me move us on to that. Now, hopefully you've got in front of you, everybody, a screen that says questions. It's got my email address and Natalie's email address there. So please do take a note of that. And if we run out of time or you have any particularly specific question that you would like to ask us, feel free to email either or both of us and ask us that question. What I'm going to try and do now, while still screen sharing, is have a look at the questions. Or I wonder, Natalie, I've been talking for a bit, haven't I? Would you like to have a go? And just make sure you unmute yourself and just have a go at seeing if you can see the questions. And
okay, brilliant.
Do with that.
So we've got a question about firstly the presentation slides. I should note those will be sent round hopefully by the end of this week, sent out to all the participants. So you will get a copy of those. And don't need to worry about that.
One, Natalie. If they can all be easy like that, I'll be very pleased.
All right, so there's a question here about the specific rules in relation to terms of ensuring tenants stay in the property. So when I mentioned people have to stay in the property and those clauses in the agreement, someone asked, can you possibly advise on when such a clause may become an unfair term?
Oh, that's a good question.
That's an interesting question. I think in relation to that is that when I was dealing with the staying in the property, that really looks at the personal contract. So that's where a license or a personal contract, because if that's a tenancy, then obviously it's not going to be a fair term. It's not going to be a tenancy in any event because they're not going to have exclusive possession because they're told what to do and they've got control. So it really, I think, falls into the personal contract aspect. And then I think the reality is, when you're looking at what the business model is of the property guardianship scheme, the business model is to secure the property and secure the premises. And so given there is the intention to form that legal relationship because of that business model, I think it's unlikely that a term which makes the tenant or the person that's staying in the property has to stay there for a particular period of time. I think that's unlikely to make it unfair.
I agree with that, Natalie.
Iris, what do you
Yeah, I
disagree?
totally agree with that. I mean, I hadn't, until that question was answered, I'd never thought of that question, but my insight is that's right. The Unfair Contract Terms Act talks about reasonableness as the test of unfairness. And this is exactly as you say, Natalie, this is the whole point of the contract, is to secure the building. Obviously, the person gets somewhere to live, but actually, generally speaking, the business model is they don't pay anywhere near what they would pay to live as a tenant or as an ordinary licensee in a nice building. They pay a significantly reduced license fee, and they know that their purpose for being there is to secure the building. And I think it must logically be reasonable, but that means they have to be there for a certain amount of time to make sure the building is in fact secured. So I think while unfair terms, because they're contractual, it's a contractual question, you will always be answering it based on a reading of the specific contract that you're looking at, and you will never give a general answer to that question in a real case. You will always look at the actual contract. I think as a matter of training, as a matter of thinking about the abstract law to this afternoon in this webinar, I think the broad answer is, I think it's quite likely to be a fair term. That's my feeling about it.
Yeah. I'm struggling with the logistics of reading the questions whilst you're still talking.
Well, I mean, can you see them on the screen at the moment, Natalie? Or
yes, I've got them.
Okay, I can see them as well. I don't know whether that means everybody else can too, whether only I can see them, but I can see an interesting question here about the remedies for disrepair should the rights of disrepair be purely contractual. So in other words, where you don't have statutory entitlement to damages for disrepair, but only contractual. And I don't know, I mean, what do you think about that, Natalie? I mean, it seems to me that it's a matter of contract then, rather than a matter of statute. That is the basic answer.
That's precisely what I was thinking, because exactly what I thought. It's the contractual relationship. I think it's unlikely that there will be disrepair clauses in a license in any event. I think you said that in terms of the whole business model being these properties are usually going to be derelict. There's going to be other issues in relation to that. So I think it's unlikely that they're going to have anything specific mentioned about it.
Yeah.
So that's where I think that lays.
I agree. Let's see, what about this one? A guardian company identifies a specific room for the occupier on the license, but still claims that the occupiers don't have exclusive use because the company retains keys and turn up unannounced wherever they see fit. Could that be a tenancy and then an offence also under the Protection from Eviction Act? That's an interesting question. What do you think about that, Natalie?
Yeah, I think the starting point. I think the starting point is to decide whether or not that's a tenancy or a license, and I think the first thing is what I said earlier, is that you need to look at all of the clauses and everything that happens. I don't think it's enough really for me to determine exactly what the set of circumstances here are. But when considering the cases that I've referred to previously, if it's the guardian company that allocates the room, it's more likely to lend towards it being a tenancy, whereas, and this is contrasted with the inspection aspect that this question deals with, because if an individual if the company turn up unannounced, that really lends towards the fact that they don't have exclusive possession. So and then for it's not a tenancy. So I think more really needs to be looked into about the specific terms of that agreement and precisely what is happening. Because if they have the keys and they're able to turn up unannounced and inspect the property, then they don't have that exclusive possession, and it's not a tenancy. Iris, I don't know if that's what you're considering.
Yeah, I think ultimately, I think it is the wrong way around to think about the potential for trespass before thinking about what the status is. If in reality, each occupier has been given a room and a key, but they've been told that the guardian company retains a key, and I think importantly that the guardian company retains the right to move people around between different rooms. So I'm now looking at a particularly clear situation, and importantly perhaps as well, the guardian company actually does it. It actually does move people around or indicates it's going to move people around. Then that's very likely to be a license arrangement, not a tenancy. And then there isn't exclusive possession, and it can't be a breach of the Protection from Eviction Act, because the nature of a license is precisely that the licensor is entitled to move people around because they don't have exclusive possession. So you really do have to start from that question. And then if in fact, let's say there's a piece of paper, a contract that says you'll be given a room, but we'll keep a key, we'll go in whenever we like and we can move you around. But those individuals, those occupiers are then living there for several years and nobody ever does that. Yeah, everybody keeps their rooms. Yeah. The landlord turns up, or the guardian company turns up once a year, and they knock and they ask for permission to come in, and then they say, sorry to disturb you, see you next year. Then actually a court is going to say, well, in practical terms, that's a tenancy. And then if they do suddenly decide to turn up, turn the key in the door and barge into the room that person has been occupying for the last several years, then that's going to be a trespass. But that comes after you've reached the view about whether or not the occupation is a tenancy. That's
I completely agree with that. Iris, there's a question I think which for you really. It says, in terms of the property being a HMO, what would happen if the property was owned by a local authority in terms of licensing?
Yes.
So is there, I think it's supposed to be, if there was a sublease, would this make it licensable?
This is an interesting question. And the answer to it probably lies in the exceptions that are in Schedule 14 to the 2004 Housing Act, which is the act that creates the licensing, the HMO license, the current HMO licensing regime. And Schedule 14 is the exceptions from licensing. And one of those exceptions is where the person in control of the building, or the person managing the building, is either a local authority or in fact a registered provider of social housing as well. So either a local authority or a registered provider of social housing. If that building is managed or controlled by local authority or a registered provider of social housing, then the licensing provisions in the 2004 Act do not apply. But what does that mean? What does managing or controlled by mean? It doesn't necessarily mean what you think it does. It doesn't just mean that the local authority is actually managing the building day to day, making sure that it's clean and dealing with queries from the occupiers about issues that arise in the building. There is a specific definition in the 2004 Act of person managing, which is in section 263 of the Act. And that, in fact, defines management of a building as a person who receives the rent or license fee from the occupier, or who has an arrangement for someone else to receive the rent or other payment on their behalf. So in guardian arrangements where, say, a local authority is the freeholder and there is a guardian company that collects the license fees, but the guardian company does so as an agent for the local authority, which some guardianship contracts do say sometimes, or if in fact the guardianship company passes some or all of the rent back to the local authority as freeholder, or the license fees back, then Section 263 says that means the local authority is the person managing the building, and that means that it's not licensable. So the question ultimately depends on the definition of management or control in Section 263 of the Housing Act. You have also asked, Janet, who's asked this question, if there was a sublease, would this make it licensable? I think quite likely, if there was a sublease, that would mean that the guardianship company was keeping all of the rents or license fees for itself, and had its own legal rights, its own legal interest in the land, rather than being an agent. That makes it sound to me more likely that the local authority freeholder then is not receiving any rents or license fees. It will depend on the circumstances of the particular arrangement, but it is possible, certainly, that a guardianship company, which is a leaseholder from the freeholder and is then granting either subleases or sub licenses, that in that sort of situation, the guardianship company would have to license the building, because arguably then the freeholder is not managing or in control of the building. That's an interesting one. Right, let's see. We've got a few more questions here, Natalie. Have you got anyone here that you particularly fancy the look of?
Okay, so I'll there's a point really of clarification. So it says, would you be able to go over the section where you mentioned that the claimant in the possession claim ought to be the freeholder rather than the guardian company, and what is the basis for that? So I think that was something you yes, that was your section.
That was on the basis, yes, only because that was on the basis that the freeholder is the landlord. Yes. What I'm saying is, and there are lots of cases that say this, it used to be a question that was open and has now been resolved, that an agent, a managing agent or a controlling agent of a building who is not the landlord cannot be the claimant, cannot be the party that brings possession proceedings. The named claimant in the claim form has got to be the landlord. And if the contractual arrangements between the freeholder and the guardianship company are that the guardian is a mere agent for the freeholder, rather than being a sub-lessee, or sorry, not a sub-lessee, a lessee who then grants sub-leases or sub-licenses, if the guardianship company is a mere agent, then it cannot be the claimant in the claim. And if it is, the claim will either be struck out or there'll be a need to amend to add the freeholder as the claimant. However, if the guardian is the landlord, properly speaking, because they have received an interest in land from the freeholder by way of a lease of some kind, a lease of some fixed length, and then they are granting licenses out of their own legal interest, then they are absolutely the correct claimant in a claim for possession. I hope that makes sense. Interesting question here, Natalie. Should local authorities pursue licensing objectives robustly in light of the somewhat tenuous status of the guardianship model where these are in existence? I think if we were doing a small webinar with, say, 20 people on it rather than 80 people on it, I might open this up to everybody else to see what they think, because there's no legal answer to that question, is there? That's a policy question. Yeah, it's an interesting one. I mean, we were discussing, weren't we, Natalie, before we started, that quite often these contracts are in an absolutely horrible state. You know, they're badly drafted, the guardianship contracts, and quite often guardianship companies seem to sort of revel in the uncertainty and ambiguousness of their documentation, almost as if it's done on purpose to make things more complicated and more difficult to deal with. Now, local authorities often have issues of reputation and how the public perceive the local authority, and they have to be very careful not to be seen to be on the side of what is perceived to be a disreputable guardianship company. On the other hand, there are plenty of guardianship companies who do a good job and who look after commercial property in a way that's valuable and should be protected, should be looked after and assisted. And there's no reason to pursue licensing if in fact it seems obvious that the local authority is the controlling party and therefore there is no obligation to license. That would just be, an unnecessary burden on a guardianship company. I don't know what you think about that, Natalie, as a matter of policy.
I think it really must be a matter of their policy, and also considering each on a case-by-case basis, because there will be instances where individuals are living in properties that are completely inhabitable and potentially cause serious risks to those occupants, and the local authority may find themselves in difficulty reputationally or otherwise, in terms of whether they don't act. Yes, there are the particular model in terms of they're there just for a particular purpose, but in some instances it is right that local authorities intervene. And I think when looking at the sort of tenuous nature, and I think it is right, we were discussing about the purpose of those drafted agreements between the freeholder and the guardian companies, in terms of why sometimes those agreements aren't very clear, and why they don't really specify in as much detail as possible what their particular rights are. There are, I think, particularly, I think there's a lot of these sort of types of issues in Bristol, lots of sort of disused buildings, and that's where a lot of the recent case laws come from. I think there will be particular issues in there if the local authority didn't act, and so really you've got to look at what do I need to do and when do I need to do it, and look at those particular circumstances of what you're dealing with there.
Yeah, and there's no harm in I think in working with guardianship companies to try and resolve these things without the need for expensive litigation. Sometimes a local authority is in the very uncomfortable position of having perfectly good complaints and valid complaints being made by the occupiers of the building about how it's being managed, and at the same time having perfectly valid issues raised by the guardianship company about the value of the service that the guardianship company is providing by securing those buildings. All I can say is it's a difficult question and one that will, that will require some careful thought. Natalie, let me ask a question.
Oh, so go on.
There's one here which I think is very much along the lines of the things that you were talking about exclusive occupation. Is the reason merely putting a clause about a guardian company coming in when they want or moving people doesn't always mean the agreement is a license, is because the status of the occupier is about substance over form, i.e. if in practice the clause is never used, then in substance it looks like a tenancy. Is that a valid way?
That's a valid summary, and that was essentially what happened in there's another case of Camelot and Roynon. So that was a case, it's an unreported, I think it's a Bristol County Court case, where that tenancy, it was decided that was a tenancy as opposed to a license, even though on paper it said it was a license, and that was based on the particular circumstances of that case, because Roynon was an occupant of, I think, 2 rooms in that disused building, and no one came and inspected for 3 years. He had exclusive possession essentially for 3 years, even though the agreement said that they could come in and do X, Y, Z, but they didn't do that. So there were other things about it. For example, he had a key to his rooms, but it goes back to the sort of guiding principles in Street and Mountford, which says you can't just look at the terms, you have to look at what's happening on the ground. You have to look at how is it being applied, and you can't call something one thing and you can't call it a license, but in fact it's a tenancy. You simply can't do those things, and you therefore it really is looking at the substance of what in fact is happening, on a day-to-day basis.
And I certainly would always advise, if I have a case where I'm advising a freehold, an owner of a building, a freeholder, who is using a guardian company or is considering using a guardian company, that not only does the contract need to say as much of these things as it can, we'll hold keys, we will access, we will inspect whenever we want to, we will move you around, and all of that. But there should be a regime as part of the business model. There should be a regime of actually doing that. So going around, carrying out the inspections without warning, telling people, right, you've got till tomorrow evening to move around. I want you over there now to protect that part of the building, and I want you to move over here to protect this part. And quite properly and openly, that is intended to ensure that the contract is carried out in substance, rather than simply being a piece of paper that is never complied with. That should be part of the guardian company's business model, to ensure that they can obtain possession effectively if possession is required. And they will do that by taking the steps that they say in their contracts they're going to take.
Precisely. So there's a question here now, which essentially says, could you advise on the current situation at the courts and how quickly a possession order might be granted in a typical property guardian property with the current backlog? So that's a good question. I think a lot of it depends, in my experience, and what I'm seeing day to day, on the court that you're dealing with, the court centre that you're dealing with, because some courts are getting through things much quicker than others. I know
I've had some cases this week where a couple of them where possession proceedings were issued in August, around the time that the stay was lifted, and the first hearing hasn't happened until now, February, on straightforward possessions. So that's in one of the London courts, and I think the London courts are absolutely overwhelmed, and they are slowly moving towards telephone hearings for the initial possession return date, but that is probably not as efficient as it could be, and slow. And I also had a case recently where we were seeking a very, very, very urgent injunction in relation to a possession matter, in relation to a dangerous state of condition of the premises. And the county court listed the emergency hearing from December, the 1st of December, I think we put it in. It was listed yesterday, I think, 2nd of February. So we ended up having to make a High Court application for the injunction, because the High Court dealt with it that day. The High Court dealt with it straight away, but the county court just wasn't willing to do things quickly. So I think it is slow.
Yes.
It is a residential possession matter, ultimately, because the guardians, whatever their status, they are living in that building. And so, you'll have all the problems that residential possession hearings have got at the moment, sadly.
Yeah, I think there are, in my experience, the courts are trying their best to do them via telephone. So I've had a few via telephone to try really to get them dealt with as quick as possible. But those are the initial hearings, because what you'd usually get in sort of the London courts are sort of the back-to-back 5-minute hearings, which aren't going to be possible, social distanced. So they're working their way through, and I've had similar sort of timescales of sort of September being dealt with this month, or last month rather. So thereabouts getting there, but that's a sort of average timescale from both Iris and I. Iris, I'm just going to note where we are getting close to the 6 o'clock time, and we do have quite a few more questions.
Yeah, well, let's wrap up. I was thinking maybe wrapping up with something a bit more general. There's one, just very quickly, one very straightforward question that I think would be worth answering, which is the very last one in the box, Natalie, which is, would the impact of COVID preventing inspections be taken into account about whether the guardian company is acting in accordance with a contract? I think, tell me what you think, Natalie, but I think yes. So long as it's not, for 10 years they've never inspected, and now they're claiming it's COVID. But if genuinely the guardianship contract started in March, and since then there haven't been inspections, I think it's perfectly valid to say, well, there would have been, except that we're not allowed you know, to because
yes, I'm of exactly the same view. Yeah, certainly.
Okay, and then I'd be interested to know what you think about this, Natalie. This is a nice sort of broad final question, I think. Do you think property guardian management companies should be in a government redress scheme, a sort of ombudsman type scheme, in the same way that lettings agents are required to be?
I think there is very good scope for that because of the issues that we've already considered and discussed. I don't think there is political motivation to do that just yet. But I do certainly think, because there are people that are living in properties, and there are various issues in relation to disrepair and unlawful eviction, that it would be helpful to be part of a scheme, because there are lots of things that we know about tenancies and tenancy agreements that secure secure the tenant. But I think in this instance, where we're looking at, if it's a license, the purpose is for the building. I'm not sure how well that would go down in terms of providing a scheme, but I certainly think for the occupants, it would certainly be helpful. Iris, what do you think?
I think so, and I think the reason why, I mean, I certainly think it would be useful. I think the reason why it hasn't happened is it's still a very young industry. You know, lettings agents have been around a very long time, and the longer an industry is around, the more rules build up around it, and there's an impetus to do something to keep the quality of the people who are in that industry at a high level. And so now, you know, these days, you know, you can go to a letting agent, and if they're a member of the schemes that are available for letting agents, you know, you can broadly trust them, and if something goes wrong, you've got a redress scheme that you can go to. Well, there are not yet enough horror stories, I suppose, coming up about guardians. There are not yet enough of these cases for that to have happened. But I think there is a real chance that we will have a lot more of this, not just because it's a model that seems to have some success, but because, sadly, I think we're going to have a lot more empty commercial buildings in cities with the way things are going this year. And those buildings will need securing, and people need somewhere to live. And it is, in some ways, an attractive option for people because it's a cheap way of living. And so I think we are likely to see more and more of it. There will be bad guardian companies and good guardian companies, and there will in the end be an impetus. Quite often it comes from the good guardian companies to want to regulate the bad ones so that the industry doesn't have a bad reputation. So I can see it happening, but whether it does or not and how long it will take is another question.
Yeah. Okay. So just to wrap up, Iris, the presentation slides will be emailed out. This is being recorded, and so I'm sure we can ensure that the recording does go out to everybody who missed any part of it.
I think it gets put on our extremely exciting YouTube channel.
Yeah, so you can
probably everybody on this webinar probably spends most of every day watching. So it will go on there. So you'll be able to watch it. There'll be a link. I think a link will be sent out by the clerks to all of you attending, and everybody who expressed an interest, to let you know that the recording is available to watch online.
Brilliant. Thank you all very much. Of course, you've seen that our email addresses are and we're at the bottom of the slide. Do feel free to contact any of us with any queries and questions you have resulting from this seminar. Thank you very much. It's now just past 6. Unless, Iris, you've got anything else to say, I shall say goodbye, and thank you very much for joining us.
Thank you, Natalie, and thank you to everybody for attending, and goodbye.